All right, thank you for joining today. I call the December 12th, 2024 meeting of the Police Advisory and Oversight Board to order. We will begin with an introduction of members.
Todd Spellberg.
Joanna Johnson.
Tanya Graywitz.
Conrad Thomas.
Lucretia King.
And Scott Paul.
Do we have David? Attending virtually?
He's in.
He may have, maybe his mic's off or something.
Okay, I'm going to just continue on here. So the next item on the agenda, or excuse me, the next item on the agenda is to approve the agenda. Can I get a motion to approve the agenda?
So moved.
Can I get a second? All those in favor say aye.
Aye.
All right, opposed, same sign. Motion carries. The next item on the agenda is to approve the minutes for the November 14th, 2024 meeting. May I get a motion to approve the minutes?
So moved.
And a second?
Second.
All those in favor say aye.
Aye.
Aye. Motion carried. The next item we have is public comment period. I don't believe we have anybody signed up for public comment, so we'll just move on to the next item, which is our brown bag date discussion. I know that this has been on the agenda a few times, and we were trying to land on a date to have our another brown bag. I believe we had some scheduling hiccups with some missing individuals and people not able to respond. And so I wanted to have a little discussion about that and to try to land on a date that we can hold the brown bag. So I don't know if we want to utilize, I know the Chief, we were utilizing your
Yes, my exec assistant could send out a doodle poll.
send out another doodle
Yeah.
poll and try, okay.
Yeah. When we're looking into January, I take it at this juncture, yeah, okay.
Yeah.
And then any day, again, we would be available,
Okay,
other than Fridays, we won't do a Friday evening.
perfect. All
Gotcha.
right, so
Another
in
dates.
January, we'll set up a time. Are there any dates that we need to avoid specifically?
I just think the first week of January, just avoid that out.
Okay,
So starting the week of January 13th? Okay.
okay,
Yeah, sometime between the 13th and the 24th, if that, those 2 weeks.
that works good. All right.
Will-
Thank
Will
you.
we meet on the 9th? As regularly scheduled?
Yes.
Yeah, okay.
Yep. All right. Any other discussion on that? I think that gives us a good window to schedule. The next item on the agenda, if there's no discussion, is legislative updates from Chief Spolsky.
Thank you. Same things, nothing's been added to our legislative agenda. We're still moving ahead on the owner liability law for fleeing vehicles. So we've got a draft working there with some state legislators and starting to get interested folks engaged on that. So hopefully we'll have better success. Fleeing continues to be a huge issue. We've got, again, data to support all of that. We're working with other police agencies as well who have similar issues. They may not have the level of data that we do, but they're in support across the state, which is kind of what we need to get it through the legislature. So, so far, it's moving well, but we'll see what happens when the session starts. We also are continuing to move forward as part of our city package on the request to increase the fines for dangerous driving and address those particular issues. And we've also met with legislators, not just the PD, but the city, related to mental health and homeless issues and things like that. I don't know that there'll be any legislation on that. That's essentially it, unless anyone has any questions.
Chief, I just wanted to ask real quick. I know you did a briefing on the homelessness. Did you do a briefing on that recently?
The city had a meeting, and our public health folks gave a presentation, like the camping piece of it.
Yeah.
Or, yeah. And Lieutenant Mosier's probably could, a little more on top of it. He's been really spearheading that with public health. I'll defer to him, I guess, and see what he can tell you.
Wondered maybe could you recap what's new on that?
Yeah, so, I think, don't quote me on this, but I think, since the enactment of the resolution, I think we moved 41. I believe it was 40 or 41 campsites that weren't in compliance with the resolution. And that was a collaborative effort between harm reduction, the police department, public works, working through that process of, notifying, trying to get those people in compliance, and then notifying them, and then removal of the property. As it stands now, there's still some campsites out there. We've been trying to utilize our regional UAS team to go up to identify, how many campsites are still out there, their locations, so that way this winter, if they choose to stay, we know where they are, if we need to get to them for some sort of a medical emergency, and to try to make sure that they are complying with the resolution, and if not, remove those campsites. But due to the cold and then when it warms up, the precipitation, we haven't been able to get that team kind of up in the air. So it's still kind of an ongoing effort. We have weekly meetings just discussing next steps, but for right now, I mean, the winter warming stuff is going on too, so that's kind of where we're at.
Okay, thank you.
One other piece just for your information. Next week, the 19th, at 2:30, we'll be hosting a press conference here relative to our preliminary crime numbers. Obviously, the year's not over yet. We're going to cover some of that with the press and public, but also report out on the first 90 days of our traffic safety team and some of the really excellent success they've had in terms of enforcing that traffic laws and the dangerous driving and things of that nature. So it should be pretty informative. Obviously, any of the board is welcome to attend. I think we just need to know if more than a quorum will be present so we can post it prior to the meeting. So maybe the chair would just let me know if we're going to have more than, was it 4? 4 or more, yeah, and then we'll just make sure we make a notation.
Sure.
Thank you.
Yep. All right. Any other questions? And we'll move on to presentation. So the next item on the agenda is a presentation for regarding protection restraining orders. Okay.
So real quick, I mean, we've been discussing this topic, I think, for the past couple months, getting a presentation done on this. So what I asked Jordan to do was to kind of put together the presentation on the different orders, what they mean, the processes that go into place when these things are put into order or applied for. And then with that, we built in what happens on the law enforcement side once an order has been signed, is in place, and put a couple scenarios in there to kind of show you guys how these orders work in different scenarios. And if questions come up, feel free to ask, and we can answer more at the end as well. So.
All right. So I wanted to put in some terminology that is pretty commonly used within law enforcement, and also just like the civil and or criminal side of when you're getting a protection / restraining order. So a protected party is the person who's requesting the order or the victim in the case. The responding party is the person responding to the order and or the defendant in the case. Lieutenant Moser, do you want to cover shall versus may?
Yeah, so you'll see when we get into the orders, certain orders will have the language of shall, so that obviously means that if probable cause is established, it gives a mandated action by law that an officer shall make an arrest. Then there's one order where it's not a mandated, but it's a discretionary, which is a may. So depending on the circumstances, there's some discretion in whether or not the officer has to make an arrest.
Yes, and so an A misdemeanor is up to 360 days in jail and or up to a $3,000 fine. A C felony is up to 5 years in prison and or up to a $10,000 fine. Served is the terminology we use when we say that the responding party was informed that the protection order is in place. Continuance is an illegal term used to describe an extension of time before the next court hearing. So that can sometimes happen when we're not able to serve a defendant or a responding party. So the judge issues a continuance. An arraignment is where the responding party will plead guilty or not guilty, and the bail amount is determined. Disorderly conduct is defined by, this is law, right? Yes.
Yeah, I can comment on
Okay,
that one too.
perfect.
So, this disorderly conduct terminology is specific to the disorderly conduct restraining order. If you actually looked at the actual definition of disorderly conduct under North Dakota Century Code, harassing, annoying, alarming behavior, this is a little bit more detailed as it pertains to an actual disorderly conduct restraining order. And that means intrusive and unwanted acts, words, or gestures that are intended to impact the safety and security and privacy of a person.
Yes. Do you want to take probable cause?
Yeah, and then probable cause, just a reasonable belief that a crime has been committed, and the suspect in the case has likely committed that crime. So these are all kind of terminologies you'll see once we get into the actual orders.
Okay, so for an order that a protected party applies for, I wanted to put this graphic up here of like, this is kind of the chain of events, and where I made this graphic assuming that the order is approved, because it would only be like 3 steps if it was not. So the protected party completes the paperwork. This can be found online on the North Dakota Attorney General's website, or you can pick up already printed application materials at the Cass County Courthouse. You just walk in and they're right there. They turn that in. If they're applying for a domestic violence or sexual assault protection order, those are free to apply for. The disorderly conduct restraining orders cost $80. Yeah.
Just want to clarify, is this a restraining order or an order of protection?
That's a good question. So the terms are kind of used interchangeably. So protection order, order protection, restraining order. Minnesota calls them DANCOs, or do not contact order. So they're all kind of addressing the same thing. So
Okay.
yes. The disorderly conduct application is $80 to apply for. So I just wanted to point that out. So then all applications are reviewed by a judicial referee, and then the judicial referee makes a determination on if they're going to approve or not approve that order. And so the judicial referee looks at 2 main things when they're reviewing these orders, which is exigency, which is how urgent is this order needed, as well as the likelihood that this behavior will be repeated. And so unfortunately, that comes down to how well can the person denote that in their application order. And so that is why in the state of North Dakota, a certified advocate, such as at Rape and Abuse Crisis Center, can help them write that order, just to make sure that all of those details are getting in there. So they are notified if it's approved or not approved. If it's not approved, they're told why. And then they are also told there is a process to appeal that decision. And so in this case, the order is approved. So the protected party was notified of the decision. They would go and pick up the approved copies of the application, and they would deliver those to the sheriff's office on the first floor of the Cass County Courthouse. And then they disperse those for Cass County deputies to serve to the responding party. And so part of that order application is also a cover sheet of where does this person work, if you know their social, driver's license number, birthday, just any kind of information they can use on their end to help find this person to serve them. So then the responding party is served. They're given the same packet that the protected party has, and in that packet lists a hearing date. And so that's normally 2 weeks from the date of the temporary order being granted. Those hearings are always on Thursdays from 1:30 to 4:30. And so the hearing would take place. The responding party has the chance to go and respond to the order. So saying, yes, I'm okay with this order being put in place, or no, I don't want this order put in place. They don't have to go. The protected party does have to go to that hearing. And so if the responding party does or does not appear, it is up to the judge to issue that permanent order. The only the difference with this is if the responding party could never be served the temporary order, the judge would issue that continuance to make sure that he or she can be served that order, because until that happens, anything that that person does is not considered a violation until they're served that temporary or permanent order.
So just a couple clarifying things with that. You can go back to that slide. So this is the process of somebody who's applying for this. Let's use a domestic violence case where an arrest has not been made, okay? So if an arrest has been made, and we'll get into that with these other ones, it's a completely different process that doesn't have as much of a burden on the victim. This would be a case of maybe an individual's involved in a relationship that's violent, and maybe they're receiving services, but it necessarily hasn't been reported to law enforcement. Maybe law enforcement doesn't know about it. This is the process that they can go through, and different resources can help them go through this process to apply to get that protection order put in place. And then the one, when the deputies serve the responding party, like Jordan said, that's the temporary order, and once that person is served, that temporary order is valid. So I mean, if they violate the order and law enforcement has contact with them, then enforcement steps can be taken. So that's the whole point of that temporary order, that allows us to be able to intervene before that permanent order can be put into place.
So if the person is elusive of being served, no action can be taken?
Until it is served on them, correct. We won't even, I shouldn't say we won't know about it. We might know about it because we've had instances where the person that has applied will have a copy of it, right? But then we'll call out to the jail and find out that it has not been served. They haven't been able to find the person, so it hasn't been served. And so at that point, yes, we would not be able to take enforcement action.
Can I just make one point of clarification? You indicated the North Dakota Attorney General's website. It's actually the North Dakota Court's website,
Just kidding. North Dakota
ndcourts.gov.
Courts
So,
website,
and it's under self-help. So that's where those forms
courts.
are.
yeah. Thank you.
And I have a question too. After the hearing takes place, so all orders are permanent after that? Or does the protective party have to, after, say, a year or so, reapply somehow?
Yeah, so that's a good question. So the standard times for orders to be considered permanent is 1 to 2 years. That's kind of the common starting point for judges. However, if you put in there 5 years, 10 years, and the judge thinks that it's a good justification as to why it's outside that norm, he can grant that. So they would have to reapply once they get close to that time lapse.
If the arrest is made in a situation like this, is there still that $80 entry fee or application fee in every case?
Just for the disorderly conduct restraining orders, and it's just for when you submit your paperwork. So afterwards, when you get your permanent order issued, you don't have to pay the $80 again.
Okay.
If that's where
And
you're
I think when
getting
we
at.
get into the orders and what they mean, you'll see why that particular one maybe has a fee with it as opposed to the other ones.
Got it, okay.
Okay, I have one more question,
Yeah.
I'm sorry. When the packet is given, to the offender, I care, does that have the personal information of the protected party, like their address and their phone number and stuff?
No. So all of that is redacted by the court system. However, they're given a copy of why that order was requested. And so if it's very specific to that person and another person, it would be kind of easy to figure out, okay, this is who served it to me. But they do not have their phone number, address. They do have a right to face their accuser, so their name is on it, but none of like where to find them or contact them or anything like that is on the order.
Thank you.
Any other questions? All right. Okay, so kind of the officer protocol when they're dealing with the call for service, of how we find out about these orders that have been, put in place, if they've been served and all that. So if officers are out on the street and they're, on a call for service, they will run the names and dates of birth of the people involved in that incident. if there's an order, and if the order has been served, it'll show up in quiz, what we call a quiz hit. So if they run it through dispatch, dispatch will see that. If the officers run it on their computer in their car, they'll see the quiz hit, and it'll say that there's a, order prohibiting contact, and it'll say that, this individual is a protected party, or this individual cannot have contact with this protected person. What that does, if it's dispatch that sees it, they'll let the officers know over the radio that, hey, the person doesn't have any warrants, but we are showing an open protection order. And then the officers will be like, can you tell me who the protected party is? Because if they're talking to the protected party, then they'll have them call over to the jail to confirm that order. And the officer's protocol is the same for that. I mean, they can call the jail themselves too and say, hey, do you have a confirmed protection order of protection for this individual? And then once that is confirmed, and if probable cause is established, depending on the type of order, depends on what the next actions are. And we'll get into that a little bit, but certain orders, if it's been violated and there's probable cause, the officers shall make an arrest, which means they have to make an arrest in that certain case. So that's kind of the steps of how we find out on calls for service if there is a protection order in place.
Okay, so for domestic violence protection orders, I want to kind of go over the temporary orders, permanent orders. So, like I said, this is issued for the ones that protected parties apply for themselves with an arrest has not been made. After review of the judicial referee, again, it has to be served to the responding party before it is in effect. Any contact made before is not a violation. Temporary orders expire after the hearing. So if there is a permanent order granted, the person is still protected because most times the permanent order is able to be served to the responding party because they're in the hearing. So the judge signs the paperwork, both parties sign the paperwork, boom, served in the same place. There is no lapse in protection, so to speak. If the judge decides to not grant the permanent order, the temporary order expires after the hearing. And then again, if probable cause is established, an arrest shall be made for domestic violence protection orders. So that is a shall, it has to happen. For permanent orders issued after the hearing, like I said, the most common time frame is 1 to 2 years from the date of approval. Again, same thing, an arrest shall be made. If either of these orders are violated, the first offense is an A misdemeanor, and then a second offense jumps to that Class C felony.
If I could just pop in, this is an important point for people to know. While those are shall arrest, Class A misdemeanor and felonies, if the jail will not take the prisoner, we're unable to do anything with them and can't make any arrest. And this is not an uncommon occurrence that we've been experiencing for well over 1.5 years, 2 years, due to county jail capacity and exacerbated by the state penitentiary decision not to take any county penitentiary prisoners. So it is continuing to get worse, and it has an adverse effect on public safety. We've been trying to work as a city with the county and work with the state on some short-term solutions, but this is a growing, continual problem that people should be aware of.
So if a person is a repeat offender, it would be a Class C felony. They're arrested, but they'd have to be released if the county jail is full.
Right? We wouldn't.
You wouldn't even arrest them?
Well, yeah, because we can't hold them if the jail doesn't take them. On those cases, we can't even book and release because I don't, right?
Felony.
Yeah, it's a felony, so. And we've had, now the A misdemeanors we can book and release, right? Or is that, we stuck on that too because we need a court date?
A misdemeanor we can.
We can, okay, yeah. Now, most often, it's pretty rare that they don't accept a felony, but that, we can't say that I know that everyone has not been taken since we've been tracking. So again, this is a pretty significant public safety issue that I think the public needs to be aware of because I don't feel like we have enough push to move the state or move somebody to start fixing this issue. It's really quite ridiculous.
And so this has happened this year where the jail is full and repeat offender?
Yes.
Yeah.
Oh yeah, we get people on warrants. I mean, just a point of data. So we started tracking this, and this has been going on since COVID. But more so, once COVID lifted in 2022, it didn't change that much. DOCR changed some regulations, I think, in terms of space, that disallowed, the sheriff had been doing some double bunking, and so that changed also. And so in 2023, we just started seeing an increase of the jail won't take them, which put us in a position where an arrestable offense, you're standing there, you should be arrested, you might even have a warrant, and I'm not even arresting you because I have no place to take you. And we just have to leave you right there, which is, again, completely ridiculous and counterintuitive to public safety. So as a department, we started to figure out what we could do to address this, because we worked with the sheriff's office to do whatever we could do, even asked them if they would book and release, and they would not do that due to their staffing issues, we're told. So we started tracking. We know in 2023 there was several hundred people that were not booked into the jail because we tracked who didn't get taken in. And we worked on creating our own booking station here at police headquarters, which opened up in April of 24 this year. And from April of 24 through November 30th, we've booked in over 305 persons, 365 charges. And so that's just a 5-6 month period of time. And those people would have never been arrested, booked, identified. And it has very pervasive criminal justice impacts when we have people that should be arrested and they're not arrested, or, you know, we don't have them properly identified. We don't know who they are. They could be not telling us the truth about their name. We have no prints and photos. So this is a huge issue that's been going on for some time, and it's an issue that we definitely need some public support to start pushing some solutions here, I think. We've been working as agencies, and I just feel like we're not getting enough. It's not getting enough attention.
So when you do not take them to jail, there was jail or fines, and the fine is not assessed either.
There's no fine, yeah.
Right.
No, if we don't take them to jail, nothing happens. There's no bond, there's no fine. A large number of these incidents are drunk drivers as well, who sometimes can go right back out and drive on the roads, and it's just huge, bad problem.
So are you aware right away of the jail being full? I mean, how do you guys know if the jail is?
Right, so we have in our policy right now, if the jail's full and it's an offense we can book and release, then they come right here and we book and release them. At least we remove them from the scene, we make an arrest, get them properly identified. And for those other offenses, we're able to give them a new court date or a future court date. But there's like felony warrants and things of that nature that require body only going to jail, and they just get released. We can't do anything with them.
So when officers have determined that they have probable cause to make an arrest, they will call over to the jail and ask them if they will take on this warrant or on this et cetera thing. And so it's kind of like, it just varies day by day, kind of what the jail capacity looks like.
And there's times they'll reach out to us as well. I know when I was working night shift, they would call and say, hey, we don't have any more misdemeanor beds. We can't accept any more misdemeanor arrests tonight, and kind of give us that status if they were full. But like Jordan said, before we take anybody to jail, we have to call to make sure that they have room for them, to include medical detoxes as well. Any other questions with that? All right, so put in a scenario here for a domestic violence protection order. So I'll just run through this real quick. So this is actually a very common call that officers get sent to, but Officer Jones is dispatched to 123 Elm Street in Fargo for disturbance. Caller stated her ex-boyfriend was no longer on scene, but was just at her front door attempting to get into the residence. Caller stated there is an active quote-unquote protection order in place. Dispatch confirms there is an active temporary protection order prohibiting the suspect from having direct or indirect contact with the caller. During the investigation, the officer reviews the Ring doorbell camera, confirms the caller's story. The order was put in place after the suspect was arrested for domestic violence 2 nights previous. The officer makes contact with the suspect in person. He admits he went to the residence to speak with his ex-girlfriend in an attempt to smooth things over. So a couple things with that. The reason that I put the first protection order in quotations is definitions are important, right? And sometimes, well, a lot of times in law enforcement, you'll hear the word protection order, and cops will use it for everything, right? They'll say protection order, and I get a protection order. Well, is it a protection order? Is it an order prohibiting contact? is it a disorderly conduct restraining order, right? Because all three of them are different. But you'll find that the general terminology that gets used is there's a protection order in place, which happens all the time. Like somebody say, hey, I have a protection order, but then we find out it's a restraining order, not a protection order, which you'll see a little bit later plays into it. So with that scenario, I would say that probable cause exists. And in that case, since a temporary order is in place and it was confirmed, that individual would be arrested because by state law, it's a shall arrest, right? There's probable cause stemming from a domestic violence order. That person gets arrested, and in this case, we call the jail and they have room, and we take that person to jail. So that's kind of scenario number one, and that, like I said, that's a pretty realistic scenario that happens quite often. Questions with that?
So with your shall arrest,
Mm-hmm.
where does the liability fall? If the state law states you shall arrest, and then I go back, if I'm the guilty party,
Right.
and do something. And
So-
you just decided to shall not.
And the officer decided not to? So the officer establishes his probable cause. The law says you shall make an arrest, and for some reason that officer's like, well, I know I'm supposed to do this, but I don't. Well, that'd be handled on a couple different levels. I mean, technically, they're not following state law. They would definitely have violated Fargo PD policy. I guess in my almost 21 years here, I don't know of a time that we've had that happen, which is a good thing.
You're doing it right
No,
now.
okay, for the jail stuff.
Yeah.
Oh, I thought you were talking like the
No.
officer makes the decision not to arrest. Okay,
It's
so
state law
that's,
that says
So-
that's a little bit
shall.
different.
That's a very good question.
Yes, it is a good
Where
question.
does the liability fall if the guilty party comes back?
No, we have no place to put them. If it's a felony, we can't arrest and release because we don't have the ability to set a court date, right?
Correct.
Yeah. So we can't do anything in that situation.
But there's a shall.
Yeah, right, but if we can't take them anywhere, then we can't effectuate the shall. That's a good question for someone else.
I'm just curious, because
Yeah.
sooner or later, there's gonna be a lawsuit there if somebody gets.
Well, absolutely. As I said, this is a huge issue that has been going on for several years, and it's amazing to me how little light it's gotten. For all of the time we spend talking about things that are out of our control. And this, to a certain extent, may be out of control a little bit, but it's just, this is a legitimate public safety concern. We have people who should legitimately be in custody, and many of them do not. They don't get there because we don't have the ability to take them in, and there's nowhere else that we can take them. The sheriff's limited on capacity by the state. The state has exacerbated that situation when last month they decided they weren't taking any more people to the penitentiary. And so they won't accept people who are sentenced to prison who are currently sitting in county jails because of that, which means that is that many fewer people that we can get into the local level. So it's just gotten worse.
And I don't think this answers your question completely, but I mean, in a scenario like that, if it's where, we're going to make the arrest, but jail doesn't have the space, I mean, obviously, all of that is documented in the report, right? Why this person wasn't arrested, taken into jail. Now, that also doesn't mean that the officers are just gonna, okay, we've done what we can, we're gonna leave. I mean, obviously, if we can't make that arrest because of space in the jail, I mean, we're gonna work with that victim, right? Hey, here's the circumstances, here's what's going on. We can't make this arrest because the jail can't take them. But what can we do? Is there a family member? Is there somebody else you can go stay with that he wouldn't know about? And we'll do everything we can to make sure that that person is in a safe spot to mitigate that or to prevent that from happening. But as we all know, it can't happen. I just misunderstood. I thought you were saying if the officer chose not to make the arrest.
No.
Yeah, because that'd be handled
'Cause that
completely
shall is
different.
there.
Yeah. Yeah. Any other questions with that? Okay, next one.
Can I add, before you go, are you able to give us guidance as citizens who a citizen would contact in regards to maybe putting a little more pressure on that specific issue?
your state representative is the people that you should reach out to, because the penitentiary is a state entity, and DOCR is the one making that decision at the county level, county commission, in terms of the jail. We are working with them on trying to figure out a solution, but there really aren't many solutions to be had without at least some assistance from the state. That, you know, when they stop taking people to the penitentiary, you just double down on a really bad problem. And you're right, I think too that this is a crisis waiting to happen in some fashion because of that.
Probably a crisis has happened.
I don't disagree with that either, but I think, yes. And again, this is, short-term solution is help at the state level with the penitentiary question. At least it would alleviate that issue. And as the most populous county, we probably have the most people in our jail that are to be sent to the penitentiary, and so that makes that quite difficult.
Okay, so the other kind of order that is issued upon a judge's discretion is called an order prohibiting contact, or an OPC. So this is issued for any crime of violence, so domestic violence, aggravated assault. I can't think of any more crimes of violence currently. Sexual assault, thank you. So this also, again, is not in effect until the responding party has been served, which would be when they go to arraignment. So, let's just assume an arrest is able to be made. They go, after a domestic violence incident, they're arrested, they go to jail. Arraignment is normally the next day. If it's on a Friday, it's normally that Monday at 1:30. The judge will say, here's all of the bond, arraignment, all of those things, and it'll say predisposition order. That normally means it's not been served yet. So then the defendant will come, plead guilty, not guilty, bond/bail is set, and then that is when the judge officially issues the OPC. And so that is when the defendant is informed that you are not to have any contact, direct or indirect, with this person. Their information is protected, because those are considered public records, so it just has their last name. I don't even think their first name, address, birthday, none of that is on there. In order for the OPC to be lifted, the protected party must request in writing and appear before a judge. And so and even then it's up to the judge to lift or amend the OPC. In my experience, I've seen judges more amenable to amending the order prohibiting contact to allow for contact regarding childcare, finances, those types of things. But I have very rarely seen a judge just blanket lift an OPC, especially in crimes of domestic violence or extreme violence. The thing I like to note with victims is that, because they see that, oh my gosh, good, there's an order for protection, that's awesome. But if the defendant goes in and that day pleads guilty, the OPC is void. It's only as good as long as the court proceedings. So sometimes they're good for 2-3 years, depends on just kind of how long the court case goes. So I always encourage victims to also apply for what we refer to as a civil order, which is those ones we kind of went over at the beginning. And so it just gives them that same level of protection once that court proceeding is over. If probable cause exists, again, an arrest shall be made. And if this order is violated, it is a misdemeanor. I don't know if you want to add anything else.
Nope. Okay. Unless there's questions. So you can kind of see where it gets a little confusing with the orders prohibiting contact and protection orders, and that's
So is
kind of where they
this
get
oh,
generalized.
I'm sorry.
No, you're fine.
Is this one where after the court proceedings are over, this is gone, and you're recommending that they go and get another order? Is that the one where they would have to pay the $80 or whatever?
If it was a case of, let's say this was issued for an assault, they would probably need to apply for the disorderly conduct restraining order, and that one would be $80. But if it was a domestic violence case, and then they would just apply for the domestic violence protection order, and they would not have to pay anything. Yeah.
Would they know that? Like, would they know that that's, who recommends that to them?
So I would recommend that to them. Rape and Abuse recommends that to them. And then Cass County has a very similar position to mine called Victim Witness Coordinators. And so they also call and make sure they know that, hey, these things are available to you. If you need translation or anything like that, we can get that for you. So there's kind of multiple layers just to make sure that that box is always checked.
And we've seen that happen, right, where the individual has a OPC in place. The person that, it was against will show up at the house, make contact with them, and then they'll call, and they'll say, hey, there's an order in place, and we're like, no, there's not, because the court case may have ended, and then obviously that individual may not have known. So. Scenario number 2, so Officer Jones again, him and Officer Smith are sent to 121 15th Street South for an active fight. When the officers arrive, the fight is over, but all parties were still on scene. The caller was a neighbor, and as officers investigated, they learned the brother of Melissa attacked Melissa's husband, Andy. Andy had just bonded out of jail after he was arrested on a sexual assault warrant where he offended Melissa. Andy came to the residence to retrieve his property, and when he learned Melissa was home, he refused to leave and was calling Melissa names, and this is when the brother stepped in. Officers confirmed that there is an active order prohibiting contact in place, prohibiting Andy from having contact with Melissa. So in this case, you can see it's domestic violence related, there's a sexual assault. He comes back to retrieve his property. His intent might not have been to violate the order, but once he learns that she is there, and there's an order in place, when he stays on scene and engages her, obviously he's in violation of that order. So in this case, the officers would be mandated to make an arrest under state law.
And I do want to add just a clarification note. So on whether it's a civil order or the order prohibiting contact, they are the responding party or defendant if they live at the same place as the protected party. It's kind of on them to find a new place to live until that is expired or over. And they are also instructed to do, because normally their first excuse is, well, my stuff's here and I had to come get it. And so they do what's called like a property exchange / standby, and Cass County sheriffs, they call and arrange that, like, hey, I'm gonna go on Wednesday at 2 p.m. and then Cass County goes, and even if Melissa was there and her husband came but he's with Cass County, it's not a violation because that's his one time. He can go get all of his stuff, but he can't keep coming back and being like, I left my shoes, I left my phone charger, like kind of thing.
Is the party charged a fee for that?
No.
But you're gonna charge the victim.
I'm sorry, can you say that again?
You charge the victim for the restraining order.
For disorderly conduct restraining order. Yeah, and we'll kind of get into why that one has a fee and the domestic violence and sex assault ones don't.
So, I'm sorry, may I ask one more question?
That's okay.
So with, in this case, Andy, he was in jail, so you can assume that he received the order, is that right? Because he was there, you know that he, I mean, because is that sometimes the case, is that they don't know that they have that protective?
And, well, I mean, a case like this, if he was in jail, on a warrant, I mean, he would have been served.
At the okay.
Correct. And then once it's served, that's when it goes into the database. So that when that individual's name is run, it'll pop up that there's an active order. And then you can run either. You can run the victim's name or the suspect, and it'll pop up. Go ahead.
Okay, so disorderly conduct restraining order, or DCRO, or what we commonly refer to as a restraining order. So this is maybe issued for incidents where the conduct is defined as disorderly conduct, like we said earlier. Similar things, not in effect till the suspect's been served. For these orders, they're only in place for up to 2 years. If a probable cause exists, an arrest may be made, and then if the order is violated, it is a misdemeanor. So this one has a fee, which I'll get into like the good and the bad. So it has a fee, an $80 fee, because we have a lot of people who perceive harassment in different ways. So there's like the state definition of harassment, and then there might be my personal definition of harassment. And so I might feel harassed because my neighbor keeps walking their dog past my lawn and they're barking at me. So I could, in theory, both, I don't know. And so I could, in theory, go and apply for disorderly conduct restraining order because this is just really upsetting me. And then maybe upon finding out that there's an $80 application fee, I might be like, whoa, I'm like a little deterred now. And so that is kind of there to kind of weed out the ones of like, this is, if you want to pay the $80, they'll review it. But like to kind of weed out things that are maybe not actually. It's more of like an interpersonal conflict management issue versus you're truly being harassed, you're truly experiencing disorderly conduct restraining orders. The bad side of that is domestic violence doesn't always meet state statute. It can be stalking, it can be harassment via a cell phone, online communication, those kinds of things that do not meet the statute definition of domestic violence. And so in that case, that order might be denied, and then the judicial referee might say, hey, you need to apply for disorderly conduct restraining order. However, the Cass County has gotten really good at, if that is the case, they waive the $80 fee. So if their domestic violence was denied and they apply for the disorderly conduct because the threshold wasn't high enough, they will waive the $80 fee. If a victim, even if it's not domestic violence, but they just can't afford the $80, I will work with the Cass County Courthouse to help them get that fee waived. So it's kind of more of just a measure to keep out frivolous, for lack of a better word, requests, because there's only one or two judges that are judicial referees, and so they're reading hundreds of these a day, and so the more not super exigent, or for lack of a better word, exigent, that's okay. So I'll let Lieutenant Mosier get into the May part for arrests.
Yeah, so this one's, a May, since obviously we don't have the, potentially the crime of violence or the domestic violence attached to it, so that's why it's a may versus a shall. There's a little bit more discretion there. And I would say probably the most common place we see this one is like for lack of a better term, a lover's quarrel, right? Two people are maybe dating. Now one decides to be with somebody else, but the threats aren't made from the boyfriend to ex-girlfriend. Now it's ex-boyfriend to boyfriend. One is maybe, taking it too far, making threatening comments, that type of stuff. That's usually when then somebody will go in and apply for the disorderly conduct restraining. That's probably where the most common place we see that, where this is applied, if that makes sense. Because there's not that domestic relationship. I'm gonna go into the, so the scenario with this one, Officer Jones and Smith are sent to Applebee's for a violation of, again, we'll call it a protection order, because that's usually what the officers are sent to. When the officers arrive, they make contact with the caller, and she presents a paper copy of a disorderly conduct restraining order. The order prohibits the caller's uncle from having contact with the caller. The uncle came to the restaurant to eat, and when he saw the caller, he made vulgar comments and gestures to the caller. Dispatch does notify the officers that they are not seeing an active order, so the officers call over to the jail and they're informed that the order was never served on the uncle. So in this case, hasn't been served, the uncle would not be arrested. Now, let's change that scenario a little bit, and let's say two things. Let's say the order has been served, so the uncle knows about the restraining order, and let's say he goes to Applebee's to eat. He looks over and he sees the person that he's not supposed to have contact with, and he turns around and leaves. He's like, nope, I'm not doing this, turns around, walks out. But now the caller's like, hey, that was my uncle, he can't be up here, he can't be within 500 feet of me, that's what the order says. And now he or she calls law enforcement. In that case, this is where that discretionary piece comes in, right? The officer will have to sift through, okay, was the order, is there a probable cause that this order was violated? So did he come within 500 feet of her? Yes, he did. But was his intent to come there and harass, annoy, alarm, or engage in that disorderly conduct behavior? If the answer is no, and it just happened to be that they came together at a public venue, and there's no further action, that's where that discretionary piece comes in, where the officers could be allowed to not make that arrest. But again, they'd have to document all that in their report. And we'll get into some of the hurdles with this in a little bit, but that would be a scenario where that may versus shall kind of comes into play.
But if he, just say he went to Applebee's because he knew the person was going to be there and he was going to, pretend he, or whatever, you know, but then is, again, making comments and being rude and harassing, you know, during dinner. What happens then?
So he goes there, he sees the protected party and now engages. He'd probably more likely not be in violation of that order. And then the officers would have that discretion to arrest.
So he may be arrested.
Yep, on that particular one. I mean, I suppose technically, if you really get into it, if he walks into a restaurant and sees the individual and goes over to the other side of the restaurant and eats supper, never engages, I mean, there's a very good possibility that he would not be arrested, because he still has the lawful right to be in that public place, as long as there's no interaction. And you can see that's one of the roadblocks, is just the public venue. That's where it gets a little sticky. So kind of laid out kind of the four main roadblocks when it comes to all these different orders. You know, the big one is if the order has not been served. Another one we run into is when the protected party, you know, contacts the responding party, because we've had that too, where maybe they'll contact them, you know, over text message or whatever. They start texting back, and then they'll be like, "Hey, he's contacting me." Well, then we look at his phone, and yeah, well, she's, you know, contacted first, or we've had it where they've invited him over. Then the person will get there and they'll call and be like, you know, things will be good for a while, but then they get into an argument and, you know, hey, he's over here and violated this order. Obviously, the public place can be problematic. And then this one is very interesting, but these orders are not valid while the person is in custody. So if your suspect has been to court, received the order, been served the order, is in jail, and let's say that he's directly calling the victim or calling the victim's brother to say, hey, tell her this, that is not a violation of the order, because the order is not valid until he is released from custody.
That's
So
due,
which we run into that quite often, actually.
and that's due to just wording in North Dakota Century Code. So that's something that is very hard, especially if they haven't bonded out. So when they're bonded out, the order's in place. So in that case, there are some measures that myself and other advocates can take, and we can ask the jail to block a number. We can, depending on what is being said, because additionally all the jail calls are recorded and we can listen to them and they know that, but it could even sometimes be considered witness tampering. So there are some measures we can put in place, but that's something that every single year, they're not called cause anymore. North Dakota Domestic Violence and Sexual Assault Coalition, formerly known as cause, they go every year and request, like, it's just one word that needs to be changed in the Century Code to make this not a problem.
I think that's it. Any other questions?
Does someone, I just want to know this because I had talked to somebody who said they had to go to Rape and Abuse to file an order. They went to Rape and Abuse said, no, we're not filing this order. Is that a thing? Like, can you just do it without Rape and Abuse, or do you have to have Rape and Abuse there?
You can do it without rape and abuse. It's recommended that either a lawyer or a certified advocate helps you just because of the legal lingo, and they know what judges are specifically looking for when they're going to grant a permanent one. But that does unfortunately happen because rape and abuse is also stretched their limit, and so they're currently right now triaging kind of who the exigency kind of thing. And so it might be, okay, you can get in tomorrow, but we can get you in later this week. And I know that's not ideal. They don't want to do that. They want to take everyone right away. But that is where, that's why the legal self-help is awesome, because there's kind of like a guide on how to write it yourself, which is really helpful. But yeah, ideally a lawyer or a certified advocate can help you, but it just depends on their wait list.
And how would you know if you were trying to do something on your own? Do you apply for a restraining order or an order of protection or a disorder? Like, how would someone know what to even apply for?
That's also all on the legal self-help. So it'll say if this, domestic violence, if this, disorderly conduct, and then it literally walks you through step by step in this line, right? Cass County, in this line, write your name. And if you're doing it on a computer, it'll like autofill it for you as you go. And so that has been an amazing resource for me to refer to victims who are like, oh, rape and abuse can't get me in as soon as I want to, but I want to do this myself. How can I do that?
Okay.
So again, excuse me, I'll just point out, it's ndcourts.gov. And it's, excuse me, the North Dakota Supreme Court website, and if you go to self-help, those forms are available also. And as far as the fees go, those are also identified, and that's under ndcourts.gov. You go to district courts, and then there's a link to fees that would be associated with filing actions in district court. So the Indy Courts website is got a lot of information.
Okay.
Any other questions?
A curious one. With the protective order, most have like a distance. The two parties can't be amongst each other. So how do you suss that out if the party is in a vehicle? Like more like stalking in a vehicle? How does the distance affect that?
So they're both in vehicles, or
Yeah, they're both in vehicles.
Separate.
separate vehicles?
Separate
They're
vehicles.
both driving down the road. I mean, there's
Like say it's a mom going home with the kids and
Mhm.
the abuser is stalking them in the vehicle.
Sure.
Is that road considered a public road or a public space, or how do you navigate that?
Yeah, I mean, so again, right, I mean, now we're diving into the investigative piece, right? I mean, are they both traveling down a public highway? But I would say that in this case, it sounds like maybe the victim now, like, went home with the child, and the suspect is now maybe driving up and down the street, or parked down the block, or
Or
something like
just
that.
following them? Say, if they're
Right.
in a relationship, they know where each
Yep.
other works. So the suspect can follow them home
Right.
from work.
Correct.
So is that a violation, or?
I would say if they're knowingly doing it, yeah. And again, like, the officers will have to get that information, right? They're gonna ask questions like, okay, so, when you first noticed him, you were here. Where was he at in relation to you? And obviously, if they say, hey, yeah, it was 2 car lengths behind me, again, traffic cameras, right? Can we look on the cameras and see, where her car was, where his car was? I think a lot of them, I think the minimum distance is like 500 feet. Well, 500 feet is 500 yards?
Yeah.
500 yards. So I mean, again, like, they'll just have to sift through that and kind of try to figure out where they were. Witness statements, cameras. I mean, I remember one time I used a LiDAR unit because they knew exactly where the person was parked, and that's what we used. We just went from the house to where the vehicle was parked, shot it with a LiDAR, which is used to catch people in speed, but it'll also tell you, their distance
Yeah.
to see if that person was, in violation of that order. But those can be difficult.
There's 2 things I want to ask real quick, and I think you can answer this pretty quick, because I think we've had this discussion one other time. So, serving, right? The sheriff's supposed to serve, but this person's elusive, and then the Fargo police come upon this situation, but aren't allowed to serve, right? I
Right.
mean, this is the deal. If it's something that the sheriff has to serve, the Fargo police do not serve? Is this correct?
Correct.
Yeah.
Yeah, and in those instances, like, I mean, if officers are on scene and they're with that individual, we can work with the sheriff's department, and ask them, hey, we're with this individual right now. Do you have somebody who can come serve that on them? Again, it's gonna depend on, time of day.
And the
that type of
difference
stuff.
between the difference between the sheriff, having to serve, the sheriff's department serving, is that if it's not the sheriff, who is it that serves?
Well,
Is it always the sheriff?
In Cass County, it's the
Yeah,
sheriff's
so it's
department, yeah.
always the county, it's not the city.
Correct,
So Fargo Police does not serve,
correct.
right?
Yeah, their civil department does all the serving of the warrants, civil paperwork, and their orders.
Okay, see, I think that's really helpful because I hear this sometimes, right? Like, they're right here and they never been served, but yet then the Fargo Police doesn't do anything, and it's like, because you literally can't.
Yeah, correct.
Okay, I just want to clarify.
So we can work with them to see if they can have somebody come over and serve it, but,
Right.
you know, like in the one scenario where it hasn't been served, we can get it served on them, but that still won't, what happened previous to being serving wouldn't, you know, we wouldn't be able to use that. Now what happens after they're
I
served?
don't think it's totally common knowledge, the difference between the county and the city, you know, and I think that gets confusing because it does seem sometimes that it's like, well, why is Fargo Police not doing this,
Correct.
right? But again, I don't think it's because people don't know that you literally can't,
Sure.
you know?
Okay. Thank you.
Anything else? Okay.
I don't think so. I think the last thing that we have on the agenda is just a mental health ILP update.
Sure. I guess I can just stay up here since I'm up here. So our mental health intelligence-led policing effort, we've been doing it for coming up on 2 years, Chief, I believe, coming up on 2 years. So just want to kind of give an update, kind of what this group is working towards, and Tanya actually got to come see it today. We had our monthly meeting today here. So really what it is we get the Fargo Police Department, and then we get the healthcare facilities, and then a lot of the behavioral health side of things kind of in a room together. Our intel analyst, Jamie Schwann, she puts together a very comprehensive report of kind of like our the top 10 people that officers are dealing with on the street for that month, and kind of what are the officers seeing, their observations, that type of thing. And then it's a very informative briefing that she gives to everybody in the room, which in hopes starts discussions on, you know, moving forward, next steps, those types of things of, you know, how to help that people. We do run into a little bit of a snag with the HIPAA stuff and law enforcement, you know, not being privy to certain HIPAA information. So that is one little roadblock, but essentially it's, we meet once a month. The information is kind of dispersed from a law enforcement perspective as to, you know, who we're dealing with and kind of what those behaviors are. And it's kind of a tough one to like quantify the success, right? But I think you know, since I took over this position, what I've seen is what we don't see is a bunch of like repeat top individuals the next month. So that leads me to believe that when we're sharing this information, you know, people on the behavioral health side are able to have conversations and hopefully do things to get that person the services they need so that law enforcement doesn't have to continue to respond to those types of incidents. Today we had a very good discussion about what we can do to make the process better. How can we get it so that information is getting out there quicker rather than being, you know, a month delayed. So we're kind of working towards that. A lot of other good discussions about the behavioral health side of things and things that they can do and work on together. But the big thing is it's just a kind of a more effective, timely way to get them the information from the law enforcement side and then let them work through what information can they share back. It could be something as simple as, hey, you know, this individual, when officers have contact with them, you know, we want this case manager notified or we want this particular person notified. Now we can go in, put an alert on that person's jacket that, hey, if you have contact with this person, call their case manager 24/7, and then hopefully that they can come out and help the person more immediate. So that's kind of the what that process is. It's been very evolving. It's not perfect. There's a lot of things we're working towards, but we've seen some benefits from it. So, and hopefully some good things to come in the future. Any questions with that?
mean, it would be ideal to figure something out. I know, you know, we've had a tragedy in our community, you know, due to mental health recently, and I just look forward to the day when, you know, these crises don't end the way they do.
Any other questions? Unless Tanya has something to add, she sat through the whole thing today.
No, I'm still processing, and I think I have some questions for later, but for right now, I was asking Joanna some information too, so, yeah, I think I will at some point.
Sure.
Any other questions? No? All right, well, thank you.
Okay.
All right, so that was the last thing on our agenda, so we will adjourn if there's no other business.
I think we should address the successful use of the flock system that happened recently. And, you know, as a board, we complain sometimes and push and prod, but it's important to acknowledge a job well done.
Fantastic, thank you.
Yes, thank you.
All right. Hearing nothing else, this meeting of the Police Advisory and Oversight Board stands adjourned. Our next board meeting is scheduled for January 9th with, I believe we'll be here at the Gateway Commons. All right, thank you.